Good morning, it's Alex Woods here. I'm currently in Warsaw in Poland doing some business, and a case has come up which has got a lot to do with the issues around cohabitation, of couples cohabiting, and the question of what happens when that relationship comes to an end. How is the property to be dealt with? Obviously this is a particularly important question for Poles or anybody who lives overseas, who perhaps have moved to the UK, has entered into a relationship and has jointly entered into a agreement to buy a property, and the financial contributions, the conduct of the parties in relation to that property, the purchase of the property, as well as maintaining the mortgage repayments on that property are unclear, and perhaps 5, 10, 15 years after the property has been bought and the relationship is broken down, the question arises, what are my rights in relation to enjoying a share of the proceeds of the asset? So the very first thing to say is that it is not like being married. So cohabiting couples may have the illusion and they may have the misconception that English law treats them in the same way that English law treats a married couple, but that is simply not the case. And the second misconception that people may have is that the issue is one purely of financial contributions. So, for example, if two business partners or two friends even enter into the purchase of property, perhaps for investment purposes, then they may be considered to be owning that property in relation to the amounts of their direct relation to their financial contributions to the purchase of the property and the payment and the mortgage payments. Now, that is not the case in cohabitation cases. In fact, what the courts are far more interested in looking at is the common intention of the parties. So this means that the key area, and indeed the starting point, will be what the property deeds, what the title deeds with the land registry will say, and issues around that. Who is responsible for the mortgage? Are the parties jointly liable for the mortgage? Was there evidence that it was clearly intended by the parties that that property was to be jointly owned, even if subsequently they made different financial and non-financial contributions to that property subsequently? Okay, so there's the broad sweep of it. I'll just give you two classic examples of areas where there's almost certainly to be some element of dispute between a couple who basically separated. They're no longer in the spring of their relationship, and they may well be at hammer and tongs against each other. So the two classic examples would be one, firstly, where one of the parties is the sole owner of the property. So it appears on the title deeds that they are the sole proprietor. They own the property in their own name. Now, nevertheless, let's say the woman has not been, let's say she's come from overseas, to give it some colour, she's met a guy, they've fallen in love, they've bought a property together, and he has been sort of financially in control in terms of the management of their financial affairs. He's bought that property in his name. She may then have had a high-paying job and made substantial contributions, financial and otherwise, to that property over a period of whatever it might be, 5, 10 or 15 years. And don't forget that in the UK, of course, you've seen property values go up very steeply over the last 10 or 15 years. Now, she's not on the deeds. The second scenario is, let's say, where, and indeed one of the case authorities on this had this sort of situation, is where both parties are on the deeds. Both parties are liable under the mortgage for the mortgage repayments. Okay, but one party has made very minimal contributions. In the case of Dowden and Stack, and have a look below for case references, in that case she was the main breadwinner. She put in the majority of the money for the purchase of the property and subsequently, and it was she who made by far the bigger financial contribution. Nevertheless, the court was concerned to look at what the common intention of the parties was at the beginning of the relationship. So those are the two scenarios. Now, the way that the law approaches both scenarios really is to say that there's a presumption that if your name isn't on the deeds, you don't have an interest in the property. You're not entitled to any of the proceeds at all. Conversely, if you're both on the deeds and you're both liable for that mortgage, there is a presumption that the property will be shared equally, 50-50, even though one party may have made much more insignificant financial contributions. So you've got, if you can watch this video and take away anything at all, it is not to be under the delusion that it's the same as in marriage, and not to be under the misconception that it's simply a case of the financial contributions. The law is looking at what the common intention of the parties was when they embarked upon the joint purchase or the sole purchase of a property. Now, so if you find yourself in that situation, I mean, let's say you think, well, I paid 75% of the mortgage repayments and I put up the deposit. Surely I'm entitled to at least 75% of the property. Sorry, my friend, you may, more than may, it's quite possible that you won't. And the burden will be on you to produce evidence to overturn the presumption that the court has that if you've, because you're entering into a loving partnership, and you want to share the property equally between yourself and the partner. That's what you intended at the time, and you wanted to, you might think, well, initially perhaps I'll make the lion's share of the contributions, but then perhaps my partner will help, or they'll help in other ways. It's not for the law to go in there and to tinker with that intention that was there at the beginning of the relationship in relation to the property, of course. So, you will have to overturn that presumption that it was to be held jointly, equally in 50-50 shares. Okay, if you can produce evidence to overturn that presumption and look at the cases below, there will be fewer of those cases. The majority will, of course, likely to go with the presumption that it's jointly 50-50 owned. But if you can overturn that, and indeed the financial contribution issue may be a factor in the court's mind, the court may say, look, you paid 100% or 90% of the financial contributions, you did everything, you were the main breadwinner, you had completely separate accounts. The court will look at a number of different factors, so we're saying that we're going to overturn that presumption. Now, then you're likely to get the financial percentage split that you initially felt that you were justified to. 75%, 25%, whatever it is. And the courts will take that broad percentage approach. It's often difficult to do anything else because the exercise of working out exactly and monetizing, counting exactly what prospective parties' contributions were is a big ask. So there you have it. And then conversely, you've got the case of, and indeed, one of the cases, Taylor, is about a wife who gave soul and body for 27 years with family, children, and indeed there was suggestions that he was abusive to her. So she gave a lot of her life to that property and to that relationship, but they weren't married. Unfortunately, she'd made minimal contributions financially to the property and she wasn't on the deeds. And the court decided that there was no common intention that the property be shared jointly. So, to conclude and wrap up, the issue is not one of fairness. The courts only sort of, once it's gone through these various preliminary stages around what was actually intended by the couple when they embarked upon the purchase of that property, only when it's been through those stages and felt there's an argument to be had to displace that initial presumption, will the courts kind of look at, well, what's fair now? It's very easy to be deluded into thinking that kind of what looks fair now is how the courts should, it's the yardstick against which the courts should make their decision. That's not the case. The courts are interested primarily, primarily at looking at what the common intention of the parties was when they entered into that relationship and what they decided. And it may well have been that they decided that the property was to be owned jointly, even though their contributions were not equal. So there it is. I will leave it there just to say the starting point, if you're kind of got this and you feel there's potential dispute here, that you should get hold of the title deeds, the property from the land registry. You should see whether you're joint tenants, tenants in common, whether there's a declaration of trust. Try and get hold of the TR1 form that you filled in with your conveyancing lawyer when you first bought the property to see what evidence there is, one way or the other, as to the common intention of the parties when they set up that property. So thank you very much for your time. There's so much more to say about this. The case references are below, but hopefully that's been at least of some initial assistance in displacing perhaps prejudices or ideas that you have about the way that English law looks at how property should be divided after a relationship, a cohabitation relationship, has come to an end.